This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the remedy of mandamus, and that proof is required of liability and the underinsured nature of a defendant before a suit can lie against an insurer. In the case of In Re United Financial Casualty Company, the Relator, the Court of Appeals of Texas 14th District on November 3, 2022, ordered the issuance of an unusual writ of mandate that if the trial court refuses to follow its instructions to abate a premature extra-contractual claim against the insurer, it will be ordered to do so. United Financial Casualty filed a petition for writ of mandamus asking the Court of Appeals to compel the Honorable Lauren Reeder, presiding judge of the 234th District Court of Harris County, to vacate the trial court's June 6, 2022 order denying United Financial's motion to abate the real party and interest Elizabeth Echeverria extra-contractual claims in an uninsured, underinsured motorist coverage suit. Echeverria was involved in a motor vehicle accident as a passenger in a vehicle operated by Uber driver Samir Tachbaroute. Tachbaroute's car was rear-ended, and Echeverria alleges that she sustained physical injuries as a result of the accident. At the time of the accident, United Financial insured Tachbaroute under a commercial auto policy with uninsured and underinsured coverage. Echeverria made uninsured bodily injury claims under this policy, and before Echeverria and United Financial resolved the claim, Echeverria filed suit against United Financial. In the lawsuit, Echeverria seeks declaratory relief to establish entitlement to UIM motorist benefits and for alleged violations of insurance code sections, breach of the duty of good faith and fair dealing, and violations of the Texas Deceptive Trade Practices Consumer Protection Act, the DTPA, and fraud. Although Echeverria has not yet obtained a legal determination that the person who rear-ended her, Mr. Lanausse-Ramos, is liable for the accident and is underinsured. Echeverria sued United Financial for the alleged violations. The trial court denied the motion to abate Echeverria's extra-contractual claims. In this original proceeding before the Court of Appeal, United Financial asserted that the trial court abused its discretion by denying United Financial's motion to abate Echeverria's extra-contractual claims. The Court of Appeal requested that Echeverria file a response to the petition for writ of mandamus. However, no response was filed. Mandamus standard of review is ordinarily only entitled to a writ of mandamus when the relator, the insurer, shows that the trial court clearly abused its discretion and that the relator lacks any adequate remedy by appeal. Most such applications are refused because of the high requirement of proving abuse of discretion. However, if a trial court abuses its discretion, if it acts arbitrarily, unreasonably, or without regard to guiding legal principles, the trial court's failure to analyze or apply the law correctly constitutes an abuse of discretion. Relator also must demonstrate that it does not have an adequate remedy at law, such as a remedy by appeal. The Court of Appeal determined the adequacy of an appellate remedy by balancing the benefits of mandamus review against the detriments. Mandamus relief is appropriate only when a trial court abuses its discretion in denying a motion to abate an extra-contractual claim in a UIM case. Abatement of Echeverria's extra-contractual claim the court found, is required until the declaratory judgment action and breach of contract claim have been decided. An insured's claim for breach of an insurance contract is distinct and independent from claims that the insurer violated its extra-contractual common law and statutory duties. UIM claims and bad faith claims have been recognized as separate and distinct claims which might each constitute a complete lawsuit within itself. A UIM insurer has no contractual duty to pay benefits until the liability of the other driver and the amount of damages sustained by the insured are determined. To recover benefits under a UIM policy, a policy beneficiary must show 1. The insured has UIM coverage, 2. The other driver negligently caused the accident that resulted in the covered damages, 3. The amount of the insured's damages, and 4. The other driver's insurance coverage is deficient. An insured first must establish that the insurer is liable on the contract before the insured can recover on extra-contractual claims against an insurer for failure to pay or settle a UIM insurance claim. Texas insurance law generally conditions recovery for bad faith and extra-contractual claims on a recovery for breach of the insurance contract itself. Echeverria alleged that pursuant to the policy, United Financial was obligated to pay her UIM benefits for bodily injury caused by Lanausse-Ramos and Tachbaroute. Echeverria further alleged that although she gave notice that she was seeking UIM benefits under the policy, United Financial failed to provide coverage. Yet United Financial has no contractual obligation to pay Echeverria UIM benefits until Echeverria establishes the liability and underinsured status of Lanausse-Ramos. The introduction of information on Echeverria's extra-contractual claims during the trial of Echeverria's breach of contract claim would be manifestly unjust. Requiring United Financial to try the extra-contractual claims with the breach of contract claim would not do justice, would not avoid prejudice, or would further convenience. Therefore, the Court of Appeal concluded that the trial court abused its discretion by not abating Echeverria's extra-contractual claims from a breach of contract claim. Finding that United Financial will lose the important right to have Echeverria's extra-contractual claims tried with a breach of contract claim, an appellate court may consider whether Mandamus will preserve important substantive and procedural rights from impairment or loss in determining whether the Relator has adequate remedy by appeal. When a bifurcated trial is denied in these circumstances, the insurer lacks an adequate appellate remedy for the time and money utterly wasted during eventual reversal of improperly conducted proceedings. The Court of Appeal concluded, therefore, that the trial court abused its discretion by denying United Financial's motion to abate Echeverria's extra-contractual claims, and that United Financial does not have an adequate remedy by appeal. Accordingly, the Court of Appeal determined that United Financial is entitled to the requested relief and ordered the trial court to vacate its June 6, 2022 order denying the motion to abate Echeverria's extra-contractual claims and grant United Financial's motion to abate the contractual claims. In my opinion, when a person brings a tort action against a person who allegedly rear-ended the car in which she was riding and claims underinsured motorist benefits, before proving the defendant was underinsured, it was manifestly unjust to make the insurer the subject of a bad faith claim. Bad faith claims do not belong in a trial seeking tort damages from a third party. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who Ask by going to zalma.com/blog, where you can see more than 4,350 blog postings. You can also view this video at rumble.com and on youtube.com. And I would appreciate it if you subscribe to the blog, to YouTube videos, or to the Rumble videos, and click on the like button or the Rumble button as you view these videos. You might also be interested in my Locals channel and in my Substack publications. Thank you for your attention.